Reporters, I will nominate you for the Pulitzer Prize for just being willing to show up today, taking this opportunity to be with us. First, I just want to thank also our guests that are here before we start. So, we entered 2019 with a government that's divided by political control, but we are supremely unified in our resolve and commitment to still deliver great public policy that moves the state of Wisconsin forward. And that is certainly true with one of the most important elements facing our state, and that's workforce development. State of Wisconsin is in many ways enjoying a 3% unemployment rate, but with that comes extreme challenges for our employers in terms of identifying and hiring and retaining workforce that can maintain those operations, maintain the great economy we have here in Wisconsin. And it's one of the core reasons that myself and my colleagues that are with me here today, Senator Alberta Darling and Representative Evan Goyke, are working to introduce pathways to employment through expungement reform. And Representative Goyke will be providing a very clinical and mechanical evaluation and understanding as to how that works. But to give you just some general understanding, expungement is a way to cleanse the slate for those who are looking to move forward with their life. And I'd like to explain it just briefly with an example. Last year we had, as part of testimony in the Assembly for a similar version of this bill, a gentleman by the name of Matthew Brunner, a gentleman from my district. And he's in his mid-30s now, but when he was a teenager he got into some trouble, like many do. A one-time offense resulted in a very low-level felony, and that single blemish on his record has transitioned from what he said was what I thought was a single offense to a life sentence. And he has spent the rest of his life trying to find gainful employment, and he came to our committee and said, I'm not asking for a handout. I want to be able to support my wife. I want to support my child. Please give me that tool. And expungement is that tool. We have talked often in both sides about having this opportunity to give people a hand up, not a handout. Expungement is a hand up. And that we're looking to ensure they're not providing a hammock, but a trampoline to prosperity. Expungement is that trampoline. And so we have a great opportunity to benefit individuals from across this great state, integrate them into our workforce in a very positive way, all while doing so in a method that has received the full participation and support of our judicial community, our district attorneys, our public defenders, and a sweet, sweet amalgam of stakeholders that are with us here today. So I'd like to turn over now for some additional comments. The leader of this legislation in the Senate, Senator Alberta Darling.
Thank you very much, Representative Steffen. I'm very happy to be here today. This represents a lot of work that we've done on expulsion, leading from our Committee on Recidivism, where Representative Goyke and I worked very hard to say, let's do everything we can in our state to get people on the right track into good paying jobs, back to their families, and onto a life that's more successful than the one they are coming from. And this is going to be a big area of concentration for me. I can just speak for myself. Corrections reform. And part of the reform has to be when one serves their time or one has a record, that one has a second chance. And expungement really is that second chance. And I want to talk to you about why we are putting so much effort into this. Number one, it's right for the individual. Now, we're talking about people who had misdemeanors or H&I felonies. We're not talking about sex offenders. We're not talking about sex offenses. We're not talking about drunken driving. We're talking about misdemeanors and H&I felonies. That's really important. And we want to make sure that these individuals who've had these offenses can go out and have a second chance. And so we're really outliers in the country. Most other states will say when one has served their time, they can come back and have that second chance. In Wisconsin, what happens if one has a court trial, one has to have, as a condition of that sentence, has to ask for that ability to have expungement. And how does one even know about it? First of all, how does one feel that they're prepared to ask for that? And thirdly, it's important to our citizens to have a second chance to come back when they feel they really find that their record is preventing them from having the kind of life that they want to have. We want to get families back together. We want to have people able to get decent jobs. And so that's why we are very much working on this. It's right for the individual to have the second chance, and it's right for our job shortage. I'm focusing on jobs too. We have a significant job shortage in Wisconsin. We have, for the last 11 months, 3% or lower of unemployment. Our employers are begging us to give them workers who have the right attitudes, who want to get back to work. And so we want to give those offenders who have records the ability to have that second chance and get back to work. And this doesn't remove that record permanently from their books. The technical books are still there with the crime, but no one else will see that. The individual will be able to go on and have a chance at a better job. And right now we need the people. We need the people to have their families have decent paying jobs, and we need to have the chance not to have so much recidivism. On our recidivism committee, Evan, as you know, we found that individuals went back to prison often for having offenses or having their terms of their parole violated, not for committing crimes. So we need to make sure that we get people off on the right track and off to a better future. So thank you for your attention. I want to make sure, just repeat, we're not talking about major felonies, sex offenses, drunken driving. We're talking about misdemeanors and H&I felonies. We're talking about jobs. We're talking about building the workforce, and we're talking about giving people a second chance. So thank you. Evan, would you like to come up?
Thank you, Senator Darling. Thank you, Representative Steffen, and for all of you being here today. I'm coming up on my 10-year law school reunion from Marquette University Law School. I haven't decided if I'm going. Maybe if I get in the gym a few more times between now and then, I'll have the courage to go. But my first job out of law school was as a state public defender in Milwaukee County. And as a trial lawyer in criminal courts, I argued for expungement for my clients. I saw firsthand the limitations of Wisconsin's current law. And when elected, it became a priority of mine to fix this state statute and give greater relief to individuals across the state. There are 41 of the 50 states in America that offer some form of expungement or criminal conviction clearance. We are unique among the 41 in requiring that decision to be made, and this is the magic sentence, at the time of sentencing. That means in the courtroom, when the defendant is being sentenced, the judge must take an affirmative position and enter that language on the judgment of conviction, or else the defendant is not eligible for expungement, regardless of how long they're crime-free or what they do to rehabilitate themselves. So our bill takes that provision away. It allows a judge to make that decision at sentencing if he or she desires, but it also allows the defendant to come back after they have completed their sentence and petition for expungement. There are 5 states of the 41 that offer expungement or clearance that have some form of age restriction, and Wisconsin is one of them. We've had expungement on our books since 1975. Originally, this was only for 18 and younger, then 21, then 25, and under this legislation, we eliminate the age 25 restriction, giving access to individuals that were 26, 27, 46 when they committed their offense. We also apply those changes retroactively. We believe that it would be unfair that somebody 20 years ago under an incomplete law not have the same type of relief of defendants moving forward. these changes in our legislation bring us in line with our neighboring states and the majority of states that have expungement laws. I want to publicly recognize the Badger Institute and the Wisconsin Policy Forum, two Wisconsin-based think tanks that have studied this issue. They have done the 50-state comparison. I direct you, if you have greater or more in-depth questions on where we stand, to those reports. They're incredibly in-depth, and what they show is that we are an outlier in our expungement law. So what we will have is a procedure whereby individuals that complete their sentence, and completion means in our bill paying their fees and their fines, restitution owed to any victims, completing their term of supervision, community service, etc. They must then petition to the court, and they have to go back to the sentencing court. So there's no form shopping allowed under this law. You go back to the county, and when practicable, the judge that sentenced you. There's then a hearing that gives the district attorney a seat at the table. The district attorney will comply with victim notification, and the victim, through the district attorney, will have a voice in this procedure. The court then has the discretion, and there's current law is maintained that if the defendant will benefit and society will not be harmed, that's the standard. If the defendant will benefit and society will not be harmed, the court may expunge the record. So as Senator Darling was mentioning, this bill does not change the crimes that are eligible for expungement in Wisconsin. It does change who's eligible under those crimes. It doesn't change the burden or the standard that courts must apply. And just because you're expungement eligible doesn't mean that you get your record clear. It means you get a day in court. It means you get the opportunity to ask for this relief. We think that this is a pretty comprehensive reform to our expungement statute and addresses a number of the major issues brought up by the think tanks that I've mentioned previously. Now, I mentioned that I was a lawyer in the criminal system and have argued for expungement motions at sentencing hearings. But there is a friend of mine here today from Milwaukee that I want to introduce. I do want to give a shout out to my neighbor and fellow Milwaukee elected County Supervisor Saquana Taylor, who's with us, who's leading this charge at the Milwaukee County Courthouse. But I want to introduce, for her comments, a friend of mine, Shannon McLeod, my neighbor in Milwaukee. Shannon is the founder of Clean Slate Milwaukee, a nonprofit organization whose sole mission is to get records expunged. I met Shannon 7 or 8 years ago before I was elected, but when I was running, and she grabbed me by the collar, and we became friends immediately, and we've worked together on this issue almost every day, and it's really her. She inspires me to continue to fight for these reforms here in Madison. So without further ado, Shannon McLeod of Clean Slate Milwaukee.
Hello, everyone. Like you said, my name is Shannon McLeod. I am the executive director of and founder of an organization called Clean Slate Milwaukee. I'm also the founder of Second Chance Staffing Services, and we're connected to almost every job center in Milwaukee County and southeastern Wisconsin. And I can tell you, and even in a report done by the American Job Center, 95% of the applicants that come through seeking employment have legal restrictions. They have criminal records, and they have these barriers that are not allow them to move forward. So I see firsthand, all the people that would be eligible for expungement but are not currently eligible because of how the restrictive the current law is. And also in a 2006 State Bar report, it also says that 175,000 Wisconsinites will be impacted by this law if it was to go through, which is a lot of people. That's a lot of people. And so what that would mean is for our loved ones, our friends and our neighbors that have records from the 70s, the 80s, the 90s, that do not have that opportunity at a second chance. And, the Uncle John, Uncle Steve, that have that 1991 drug conviction, that have not done anything since and walk a narrow, productive life and just want opportunity to advance. This is who that would impact. This would also impact Miss Claudine, one of my favorite people to mention, because she has a record from 1978. That was before I was even born. for soliciting, and now she can't, go into anything government subsidized. It's a housing issue, but this is a really big employment issue, and this would do wonders. This would do wonders for our state. So I stand here in 100,000% in support of this bill. And I also want to thank Senator Alberta Darling. She was there 10 years ago when the Committee on Expungement of Criminal Records was formed in 2007. She was there then. She's there now. Thank you for your commitment.
Thank you for your work.
Thank you, Evan. There's no way in the world I can thank him enough. Like I said, we've been on this for a very long time. I also want to thank Representative Steffen, and I also like to return it back to him, but thank you all for showing up to a very, very important cause for our state, a state that we all call home. Thank you.
I mentioned it briefly, but I just want to reiterate a couple important things. That the way you can often tell the quality of the public policy is by who's involved with it, both from the creation and from the support level. And we worked incredibly hard to sit down and collaborate and craft this legislation with the direct input from judges, the director of state courts, district attorneys, and the public defender's office. The three primary operators in the courthouse, the ones who have to deal with this every day. And to find a pathway forward with that was something that shows how the quality of the legislation. And I think you can also tell the quality of the politics also when you have such a diverse group of support. As mentioned, clean slate, wonderful, wonderful job, and certainly you'll see in the press packets the incredible diverse list of business groups from all around the state that are showing their support for this legislation. And then some other groups that are actively involved, two of them that are going to speak now, who have been directly involved with this initiative, and in particular with finding different pathways to employment, and I'll introduce them each separately. First of all, from Americans for Prosperity, Eric Bott.
Thank you. Good morning, and thank you, Senator Darling,
and
Representative Goyke and Representative Steffen for being here today and giving us the opportunity to introduce this legislation to all of you. Americans for Prosperity exists to bring citizens together to unite over public policy issues that give them an opportunity to improve their lives. Much of the work we do focuses on working within the institution of government to break down barriers. And those barriers might range from things like overburdensome taxation to lack of access to a quality education, or in this case, the stigma that a criminal conviction erects as a barrier to finding housing, employment, or higher education. We see the legislation being introduced today as an important first step towards reducing recidivism in Wisconsin, which will allow our police agencies and law enforcement agencies to better focus their resources on keeping us safe, while also giving individuals a second chance at life in order to become the best version of themselves that they can be and to better achieve their American dream. We fundamentally believe in the dignity of every human being and that every individual deserves a second chance. And that if we provide that to them as a society, not only will we benefit the individual, but through mutual benefit, we will all benefit ourselves and lead to a safer and more prosperous society. So we're grateful to have the coalition that we have today, the work that the Badger Institute and the Wisconsin Policy Forum have done researching this issue copiously over the last several years has really guided our efforts on this, and we're grateful again to the authors. Thank you.
In the last group, which is for the sake of time will be available for one-on-ones, is the ACLU. So Chris Ott is available if you're interested in speaking with him directly. He's with us as part of our coalition. We are so thankful for having this group to be with us, who all understand the importance in identifying and fully developing pathways to employment for those that are underserved, underemployed, unemployed, and finding a way forward for them. So I want to thank all of you for coming, and we will now open it up for questions.
Well, this legislation is similar to a bill that was introduced last session but failed to pass. So what do you think the appetite is this session?
Well, I'll start with that, and then I might even hand that off to Senator Darling after that. But so it is very similar to what was introduced last session. I was the lead author on that legislation. There was a competing bill that was in the Senate, And because there was two different versions, there was some issues that we just weren't able to reconcile it. Also, an important part of what happens in this building is timing. We were a little bit later in the game when that came out. It's one of the reasons why we're starting here in January to get this out, is to ensure we prevent some of that. So last year's version, which is very similar, passed the Assembly unanimously, 98-0. And so I'm hopeful that we'll have similar success this time. But again, some of the reasons for were more insider and clock related than substantive.
Your bill requires that a person file a petition with the court to have this done, and then the sentencing court takes it from there. At any point in time, are they required to come to the court, or can a sentencing judge require someone to come to a court to fulfill the expungement?
So there's multiple layers of procedure in the bill. First and foremost, a judge may dismiss a petition for expungement if the defendant is not legally entitled to relief. So, for example, if the individual has a subsequent criminal conviction, or their conviction is of a category that does not meet the law, so that we have a clearinghouse there for courts to not have to have a hearing on that. The courts then, if the defendant is eligible to relief, they then serve notice to the district attorney, who then serves notice to the victim of the case, and there's 90 days for the prosecutor's office to respond. If the prosecutor asks for a hearing, the court must then conduct a hearing. It is our expectation that the defendant would be there. It is a post-conviction motion, so it doesn't have the same requirement as an ongoing criminal case, say before guilt or innocence is determined, but the defendant should be there in person to make their case. They're not entitled to a lawyer, so the State Public Defender's Office, or in Wisconsin, the State Public Defender's Office will not be required to assign attorneys to expungement petitions. Expungement today is done largely pro se or by the defendant's self. There are civil legal service firms like Legal Action or Legal Aid that help in some counties, and we expect them to get more involved in this as there are more petitions filed. The court then has to schedule a hearing if the prosecutor asks for one. We specifically do not require a timeline under the bill, and that was to weigh the busy court schedule. There are some counties with one judge. In my hometown in Milwaukee, there are 47 judges, so it may be easier or harder depending on where the criminal conviction is. But the court would then schedule a hearing. The defendant would appear, state his or her case. That could take the form in an oral argument. It could take the form of written materials, of job reference, college transcripts, proof from the Department of Corrections that they completed probation and parole. And then, of course, the prosecutor is there and would be free to oppose or to agree to expungement. The victim would be entitled to speak at that hearing and would have notice.
To follow up with that, is there a fee for filing the petition for expungement?
The initial filing is free. Under our legislation, a defendant may petition no more than 3 times, and 2 times. And so there is a fee associated with the second application. And that is not out of line from the rest of the Great Lakes states.
How will this affect what information on these crimes is publicly available, either at the clerk of circuit court level or through the state's online court record system?
So under current law and maintained under this bill, when expungement is granted, the physical file inside the county courthouse is sealed and no longer publicly accessible. The companion documentation that is reflected on the website we all call CCAP would also be eliminated, and that's currently what happens under expungement law. What is not addressed in this bill, which was a component of some of the legislation last session, is that there are other agencies that keep records regarding arrests and criminal prosecutions. The Department of Justice has what is called the Criminal Information Bureau, or CIB, which has a fee-based record retention system, and this bill would not expunge or seal records maintained by the DOJ, nor would it expunge or seal records kept in National Arrest and Conviction Database by the FBI.
Why is the bill silent on this? In previous incarnations that affected the availability of records had provisions in them spelling that out. Why does your bill not say anything about it?
Are you speaking specifically to the CIB element?
Your bill is drafted and distributed here today. It doesn't say anything about how this information will no longer be available at the circuit court level or through WCCA.
Well, I guess I'm not following the question. So it's nearly identical to the version that was introduced and passed out of the Assembly last time. One of the differences, and actually the version that we passed out of the Assembly, that language is almost identical. I mean, I'm not sure I'm following the question.
Previous bills that have spoken to the consequence for records, and this one does not.
The consequence for records.
What records will be available as a result of the passage of this bill?
Okay.
According to Representative Goyke, it's going to be a total shutdown of information regarding the crimes that were committed.
So I'll do just for a second. So the CIB option is still available for public access. It's a fee-based model versus the CCAP version, which is free and you can access it on your phone right now. So there still is opportunity for individuals through that fee-based model to access the same information.
I would just like to add the important element of judicial
I just wanted to double check this 175,000 figure. That's based on number of people still living in Wisconsin with misdemeanors and H&I felony convictions.
So I think Ms. McLeod referenced that number earlier regarding State Bar report, and that was from a number of years ago. I think the best available data that we have was produced in the last 2 years from the Badger Institute and from the Wisconsin Policy Forum. The Policy Forum's data is only limited to Milwaukee County. It's really impossible to stand in front of all of you today and say there are X number of individuals that are eligible because, of course, it's a case-by-case analysis. If somebody did not successfully complete their sentence, or if they continue to owe fees or fines, those are things that aren't immediately black and white upon looking at the individual's record on CCAP, but really in the fine and small print. And it will take this type of legislation to get individuals to apply, and in part get a list of what's left. If there's $200 outstanding of restitution, this is an incentive for that individual to prioritize making the victim of their crime whole, and it's an incentive for them to finish their sentence successfully, etc. We don't have clear data, but I would point you to those two think tanks that have done the best Wisconsin-based research on this topic.
Thank you, everybody.
Thank you.
Thank you.